Hello everyone, this is Urvashi Chauhan and you are watching Courts Today by Livelaw. We bring you the latest and in-depth legal coverage. Here is a brief of what all happened in the Indian courts today. In an extraordinary turn of events, today the Supreme Court issued notices to two members of the National Company Law Appellate Tribunal or NCLAT to explain why they should not be held in contempt for rendering a judgment that violated a status quo order issued by the Supreme Court. The matter relates to the occurrences on 13th October concerning the annual general meeting of Finolex Cables. In the morning session of that day, the Supreme Court issued a status quo order. However, during the afternoon session, the lawyers raised the matter once more before the Supreme Court, saying that the NCLAT had proceeded to deliver a judgment despite being informed about the status quo order. So the Supreme Court had instructed Justice Ashok Bhushan, the NCLAT chairperson, to initiate an investigation. Inquiry report was produced before the Apex Court today. The two judicial members apparently told NCLAT chairperson that they were not aware of the Supreme Court order. But this version was disputed by the lawyers from both the sides, who said that the order was mentioned before NCLAT bench before it proceeded to deliver the judgment. During the hearing, the CJI orally expressed anguish at this. Further, the bench of CJI Chandrachud and Justices J.B. Pardewala and Manoj Mishra issued show cause notices to Mr. Rakesh Kumar, the judicial member, and Dr. Alok Srivastava, the technical member of NCLAT. The said members have been directed to be present before the Apex Court on 30th October. The Supreme Court bench comprising Justices S.K. Kaul, Sanjeev Khanna and Bela M. Trivedi today heard petitions seeking review of the Vijay Madan Lal Chaudhary judgment. Through this judgment, the Apex Court upheld the provisions of Prevention of Money Laundering Act, that is PMLA, which relates to the power of arrest, attachment and search and seizure conferred on the Enforcement Directorate. The court had also upheld the twin conditions for bail under Section 45. In August last year, while issuing notice on the review petition, a bench led by the then CJI N.V. Ramanna had observed that two aspects of the judgment prima facie required reconsideration. One, the finding that the copy of Enforcement Case Information Report, that is ECIR, need not be given to the accused, and second, reversal of the presumption of innocence. Today, at the outset, Justice Kaul clarified that the bench would confine to whether the judgment should be reconsidered on any specific point and not general reconsideration. Solicitor General Tushar Mehta argued that PMLA was not a stand-alone offence. There was a global response. Unlike other laws, PMLA is prepared by the legislature in conformity with the directions issued by the Financial Action Task Force. Accordingly, every member country has prepared their money laundering and terror financing laws. He further said that the judgment in question was rendered after a lot of deliberations, and the averment that the petitioner is an enlightened citizen and he feels that the provisions have been wrongly interpreted was not a proper ground to reconsider a coordinate bench judgment. Senior advocate Kapil Sibal, appearing for the petitioner, informed the court about the issues in the judgment. For example, the interpretation that PMLA was not a penal statute. How could a person be convicted for money laundering under it if it was not a penal statute? Second, he pointed to the finding that the copy of ECIR need not be given to the accused. He questioned as to how would a person get a bail without the same. He also objected to the twin conditions for bail. At the end, the court said that it will be addressing only the issues relating to PMLA. It also noted the objection of the SG that an academic exercise should not be carried out. The matter will now be heard on 22nd November. Stay tuned with us. In another update, the Supreme Court recently issued notice to Union of India on the question of framing guidelines for issuance of birth and death certificates through digital means to avoid delay and inconvenience to those who wish to apply for it. This order was passed in a case where the court was considering re-evaluation of sentence of a convict in a corruption case due to his old age. The notice issued returnable within 4 weeks is to be served through the concerned Additional Solicitor General. In an important observation, the Supreme Court has reiterated that consumer disputes are non-arbitrable disputes and a party cannot be compelled to arbitration just because they are a signatory to an arbitration agreement. In this case, a consumer complaint was filed by a home buyer against a builder. The builder challenged 2 orders of the Telangana High Court refusing to appoint an arbitrator. The High Court had rejected the application filed by the builder for appointment of an arbitrator on the ground that the dispute was pending before the District Consumer Disputes Redressal Forum. The District Consumer Forum also dismissed the application on the ground that the dispute was non-arbitrable. Then the builder challenged it in a review application before the High Court, which was also dismissed. And post this, he approached the Supreme Court. A bench of Justice Sanjay Kishan Kaul and Justice Sudhanshu Dhulia observed that the Consumer Protection Act is a piece of welfare legislation with the primary purpose of protecting the interest of a consumer. The court also observed that the nature of the dispute determines the forum for its redressal. In a consumer dispute, the consumer has the option to either approach the consumer forum or choose arbitration. In the present case, the consumer chose to approach the Consumer Redressal Forum, and merely because the builder had approached the court under Section 11 of the Arbitration Act, the jurisdiction of consumer courts was not ousted. And now coming to a heartwarming news from the Kerala High Court, which has reunited a 80-year-old woman with her 92-year-old husband. The husband is suffering from dementia and stays with his son. The mother is unwilling to live with her son due to some personal differences. Previously, the Maintenance Appellate Tribunal had directed for the father to be taken to his family house so that he could live with his wife there. This was challenged by the son, who wanted to take care of the father by stating that the mother, herself being old and suffering from various ailments, was not in a position to take care of the father. The son was willing to take care of the mother also if she agreed to live at his house. The second writ petition was filed by the wife to be reunited with her ailing husband and for the enforcement of Maintenance Appellate Tribunal's order. The wife contended that the husband was happiest when he was with her at their family house and that he was illegally detained by their son and kept away from her. The government pleader submitted before the court based on the report of the social justice officer that the husband was indeed the happiest in his wife's company and he wanted to live with her at their family house. Justice Devan Ramchandran observed that the wife had an absolute and inviolable right to the custody and company of her husband during the winter years of their lives. Accordingly, the court directed the jurisdictional social justice officer to accompany the husband to his family house so he could live in the company of his wife. The court also permitted the son to visit and stay with his father subject to the wishes of the mother. In the next update, the Delhi High Court has pulled up CARA, that is Central Adoption Resource Authority, for issuing mere support letters instead of NOCs, saying that NOCs cannot be made onerous for those who opt for inter-country adoptions. Justice Pratibha M. Singh was dealing with a batch of petitions concerning the issues faced by people wishing to adopt children through inter-country adoptions. Amicus curiae advocate Lavanya Raghunathan Fisher informed the court about exorbitant expenses being incurred by adoptive parents for obtaining home study reports during inter-country adoption of children. The court took a grim view of the matter. Justice Singh also said that in terms of the Modified Adoption Amendment Regulations of 2021, CARA is mandated to issue NOCs to Hague Adoption Convention ratified countries. Further, the court has directed concerned director or joint secretary in the Union Ministry of External Affairs to remain present in court on 28th November, that is the next date of hearing. And lastly, the Kerala High Court has held that a wife not knowing cooking cannot be grounds sufficient to constitute cruelty. The court was dealing with an appeal by the husband against the decree of restitution of conjugal rights obtained by his wife and challenged an order rejecting his plea for divorce. The husband had argued that their marriage was practically and emotionally dead and they had been living separately for past 10 years. That his wife had insulted him in the presence of his relatives. She also made a complaint to the managing supervisor of the company where he was working and made defamatory statements against him with a view to terminate his employment. He also alleged that she did not know how to cook. But court was of the considered opinion that the mail sent by the wife was only her desperate attempt to patch up her marriage by seeking intervention of her husband's employer for the same. The court also determined that her failure to prepare food for the husband and her not knowing the skill was not cruelty. The court observed that legally, one party could not unilaterally decide to walk out of marriage when sufficient grounds for divorce were not there. Accordingly, it refused to interfere with the impugned orders rejecting the husband's application for divorce. Thank you for joining us. If you wish to know more details about the cases I mentioned here, you can visit our website at www.livelaw.in. Stay ahead with quick legal updates only on LiveLaw. Do not forget to like, share and subscribe and support us. You can also support us by donating through the thanks button at the bottom of our videos or consider becoming a member at just 89 rupees per month.